Okay, we are now live and on the record for this afternoon's criminal docket for Tuesday, May 10th, 2022. And I'll take quick announcements if you have them. If not, we can go ahead. Well, there's Mr. Osuna, go ahead.
Osuna for the record. Your Honor, we have or formerly had number 16 on the docket, Alexander Dudley Mortimer. Mr. Mortimer is in detention. Some context on this case, Your Honor, we were originally appointed and then Mr. Mortimer's family retained Miss Alma Garza. Mr. Mortimer had an accompanying felony. When that case first got started, Mr. Mortimer discharged both myself and Miss Garza, but Judge Rose kept me on because I had been appointed and not retained. So in any event, that was a complicated felony and we were heading towards trial, and then without warning, the state dismissed that felony case. So this is the only case that Mr. Mortimer has. I've developed a good relationship with Mr. Mortimer after preparing this case for trial. I know Ms. Garza no longer wants to remain on his case because he had discharged her in general. So we're just humbly asking to be reappointed. I did remind Ms. Garza of today's setting and I did send her the Zoom so that she could corroborate what I'm saying, but I don't see her on yet. But
okay, Deputy, do you have Mr. Mortimer in your custody?
They're bringing him right now, Your Honor. He's in his way over here.
Okay. As soon as he gets there, then I'll go ahead and take you up, Mr. Osuna, with the announcement.
Yes, Your Honor.
Okay, Ms. Morales Martinez.
Good afternoon, Judge. I have an arraignment. It's what I have on Mr. Hugh Johnson. I'm not sure if I think he's still in jail, Judge.
Yes. Do you have Hugh Garrett Johnson with you? Okay. Which one is he getting arraigned on? On all of them?
I believe so, Judge. Yes.
Okay, because I don't have that in my notes. Ms. Rivera, are you showing that I need to arraign him on all of them?
I believe that they are, it's solely number 14 and 15. Let me just double check, Judge.
Number 13 are MTRs, Bianca.
Yes, they are MTRs, Judge. So it would just be 14 and 15, Your Honor.
Okay, which ones were the MTRs 13 and 12?
Yes, ma'am.
And 11 is what, just a status?
Oh, let me see, Judge. I'm sorry. Judge, he hasn't been arraigned on this one. Although there was an agreed order for a bond reduction, so this is his initial hearing, Your Honor. So he does need to be arraigned on 11, 14, and 15. I apologize.
Okay, let me see.
I signed last night for the bond. I bonded out.
On which one?
Everything.
You bonded out on everything?
Yep.
Ms. Morales Martinez, are you aware of anything?
Judge, I'm aware that I had been working on getting him bonds so that he could get, get out. And honestly, I thought he was out already, but he has some felonies also that he also got, low bonds so that he could get out.
So then on his felonies, is he in there on his felonies or what is he in there on?
He has I believe one rebel on the felonies and then a new one that he picked up, which is why he went in there, Judge.
Okay.
And the court granted him bonds on those. At the time when he came in, he was in a wheelchair. I think he had been in an accident. And so the court granted him that. But then what was holding him back were the misdemeanors. I believe there were some verifications of incarceration that had been filed. And so I went ahead and worked out a deal with the DA's office where they, gave new bonds on it.
Okay. So then, right, okay, so I'm gonna go ahead and arraign him on those three, and then I'm assuming what, he's gonna be processed so that he can be released, or are we taking up those MTRs right now?
I believe it will be for him to be released, and then I would like an opportunity to work all his cases out, Judge.
Got it, okay. Mr. Johnson, let me go ahead and have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may lower your hand. And CR 22-02-720-I, State of Texas versus Hugh Garrett Johnson, is that your true and correct name?
Yes.
Okay, and in CR 22-02-722-I and CR 22-02-721-I, Hugh Garrett Johnson is, that's the same name, so that's your true and correct name, sir?
Yes.
Okay, you're being charged with obstruct highway passageway, a Class B misdemeanor, a possession of marijuana, less than 2 ounces, a Class B misdemeanor, and a possession of a controlled substance, penalty group 2A, less or equal to 2 ounces, a Class B misdemeanor. A Class B misdemeanor carries a potential penalty of up to 6 months in Hidalgo County Jail and up to a $2,000 fine upon conviction. Do you understand the range of punishment that you can receive, sir, for the offenses of which you are charged?
Yeah.
Sir, has any court ever declared you to be mentally incompetent, crazy, or insane?
No.
Counselor, in speaking with your client, do you find him to be mentally competent and able to assist you in his own defense?
Yes, Your Honor.
Then the court is making a finding that Mr. Johnson is competent and able to assist his attorney in his own defense, and hereby enters a plea of not guilty on each of the offenses of which he was arraigned here today. Okay, so now I'll give you an opportunity to go ahead and speak with him with respect to his MTRs and these other cases that he just got arraigned on. And the felony, you have a setting on what date?
Judge, if I may, I thought I had it here and I don't, but.
Mr. Lozano, do you have a date on that, sir?
Yes, Your Honor, June 8th, 2022.
Okay, so we'll have a setting after that time period. Let me see. The 21st at 1:30, June 21st at 1:30.
Your Honor, I am scheduled to start a sexual assault case on the 20th in the 206.
Okay, we can do the 28th at 1:30.
That sounds good, Judge.
So he already has signed off on all of them, so they just need to process them, correct?
Yes, Your Honor.
Okay, I just want to make sure. I don't want anything on our end being what's holding him up.
That's my understanding is we've taken care of everything, Judge.
Okay, perfect.
And is this going to be in person? More than likely, yes.
No, on a Tuesday on June 28th, as long as he's out on bond, it'll be via Zoom
Okay.
at
Thank
this
you.
time.
Yes, ma'am.
Okay,
That is all we have, Your Honor. May we both be excused.
you certainly may.
Thank you, Judge.
Okay, Ms. Coronado, what do you have?
Your Honor.
Good afternoon. I have Cesar Escobedo. He's in jail.
Your Honor, just for the court's information, Mr. Mortimer is already here present.
Okay, I'll take him up after.
All right.
All right, that is CR 22-03324-I. Cesar Escobedo, is he English speaking or Spanish speaking?
Spanish.
Okay, Ms. Castañeda, please ask him to raise his right hand.
Sí, señor Escobedo, por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí, acepto.
Yes, I do.
Okay, in CR 22-03324-I, is Cesar Escobedo your true and correct name?
En el estado de Texas contra César Escobedo, ¿ese es su nombre correcto y verdadero?
Sí.
Yes.
And You're being charged with possession of marijuana of less than 2 ounces, a Class B misdemeanor.
Está usted frente a la corte por una posesión de marihuana, un delito menor clase B.
Sí.
Yes.
And that's punishable by 6 months in Hidalgo County Jail and up to a $2,000 fine upon conviction.
Una ofensa menor clase B tiene una multa potencial de hasta 6 meses en la cárcel del condado de Hidalgo y una multa de hasta $2,000 por convicción.
Do you understand the range of punishment that you can receive for the offense of which you are charged?
¿Entiende usted el rango de castigo que puede recibir por el delito que está acusado?
Sí.
Yes.
Sir, has any court ever declared you to be mentally incompetent, crazy, or insane?
¿Alguna corte lo ha declarado mentalmente incompetente, loco o demente?
No.
No.
Counselor, in speaking with your client, do you find him to be mentally competent and able to assist you in his own defense?
Yes, Judge, he's competent and can assist.
The court will make a finding that Mr. Escobedo is competent, able to assist his attorney in his own defense, and hereby enters a plea of not guilty on his behalf. How much time do you need, Counselor?
Judge, he has a felony pending that is set for June 1. So if the court could set it any time after that.
Okay. Does he have an ICE hold?
Yes, Judge, he does.
Okay. We can do June the 7th at 1:30.
That's fine, Judge.
Ms. Castaneda, let him know that his next setting is on June the 7th at 1:30.
Señor Escobedo, su próxima corte es el día 7 de junio a la 1:30 de la tarde.
Sí.
Yes.
Gracias.
Thank you.
Okay,
That's all I
Deputy,
have,
if you can bring up Mr. Mortimer?
Judge, that's all I have. My client and I be excused.
Yes.
Thank you, Judge. Have a good day.
Thank you, likewise. Okay, let me recall CR 21-13952-I, Alexander Mortimer, MORTIMER. Announcements by the attorneys?
Good
Yes, Your
afternoon,
Honor.
Your Honor. Alma Garza for Mr. Mortimer. And I believe Mr. Jose Osuna is also the attorney. Judge.
Yes, Your Honor. So just by way of reminder, we had been appointed, Ms. Garza was retained, Mr. Mortimer ended up discharging both of us, or attempted to anyway. I ended up staying on because I had been appointed. And I apologize, Your Honor, I had kind of laser focused on this felony because that was a more serious case. And then I set this matter for a bond reduction without realizing that me and Ms. Garza never resolved this issue in this court. I had anticipated going to trial here in a few weeks on this felony. But I am humbly asking to get reappointed to Mr. Mortimer's misdemeanor. We do have a tentative agreement with Mr. Lozano, subject to the court's approval for a bench trial. We had intended on asking for it this Thursday.
Judge, and I would make an oral motion to withdraw as Mr. Mortimer's attorney, Judge.
Okay, so Mr. Mortimer, any objection to us reappointing Mr. Osuna?
No.
Okay, the court is granting Ms. Garza's oral motion to withdraw from this case and reappointing the Public Defender's Office on CR 21-13952-I. And Mr. Osuna, I have here that I also need to arraign Mr. Mortimer on this.
Oh, yes, Your Honor, please.
Okay, Ms. Garza, any further business?
No, Judge, may I be excused?
Yes, ma'am.
Thank you, Judge. Have a good day.
Likewise. Mr. Mortimer, can I please have you raise your right hand as best as you can? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand, sir. In CR 21-13952-I, is Alexander Dougly, Dougly Mortimer, your true and correct name?
No.
Okay, what is your true and correct name, sir?
Alexander Dudley, Dudley, Mortimer.
Okay. At this time, since it's arraignment purposes, is the state making an oral motion for a trial amendment?
No, Your Honor, not at this time.
Okay. So let the record reflect that Mr. Mortimer is stating that his full and correct name is Alexander Dudley, Dudley Mortimer. Mr. Mortimer, The offense of which you are charged is assault causing bodily injury, a Class A misdemeanor. A Class A misdemeanor carries a potential penalty of up to 1 year in Hidalgo County Jail and up to a $4,000 fine upon conviction. Do you understand the range of punishment, sir, that you can receive for the offense of which you are charged?
Yes.
Sir, has any court ever declared you to be mentally incompetent, crazy, or insane?
No.
Mr. Osuna, I'm speaking to your client. Do you find him to be mentally competent and able to assist you in his own defense?
Mr. Mortimer is competent, Your Honor, and he has been able to assist.
Then the court is making a finding that Mr. Mortimer is competent, able to assist his attorney in his own defense, and hereby enters a plea of not guilty on his behalf. And what is the further announcement from the state? I mean, from the defense?
Yes, Your Honor, we've staffed 2 matters with the state. One of them is that the state is in agreement to a $1,000 cash surety bond. So we're humbly urging that agreement, the pronouncement of that agreement, Your Honor.
Okay, Mr. Lozana, is that correct?
That's correct, Your Honor.
The court is granting that agreement then. So his cash surety bond will be reduced to a $1,000 cash surety bond.
Yes, Your Honor.
And what else, gentlemen?
Yes, Your Honor. Mr. Lozano has agreed to a bench trial. We'd be ready as soon as this Thursday if the court is inclined.
Okay, Mr. Lozano, how much time do you need, sir?
Your Honor, if we could set it for Thursday at 1:30 p.m.
On the 12th?
Yes, Your Honor.
No problem. Okay, we'll have that bench trial set for Thursday, May 12th at 1:30. That'll be in person, gentlemen.
Yes, Your Honor.
And we will be in County Court 5.
County Court 5, yes, Your Honor.
Okay, anything else on Mr. Mortimer?
Not on Mr. Mortimer, Your Honor.
Okay, Mr. Mortimer, we'll see you on Thursday, sir.
Thank you.
Thank you. You have a good day. Anything else, Mr. Osuna?
Yes, Your Honor. We have State of Texas versus Lilo Rodriguez. Those are numbers 18 and 19, CR 18-15781I, and CR 22-02482I. Mr. Rodriguez has an unfiled felony, so we're just asking for time at this time.
Okay, is Mr. Rodriguez English speaking or Spanish speaking?
English speaking, Your Honor.
Okay, so, and so it's still at intake. What's the offense of that felony, Mr. Lozano?
Abandoning, endangering child with the intent knowingly, recklessly, or criminally negligent on 2 counts.
Okay. So let me, that's still at felony intake?
Yes, Your Honor.
Okay, so how much time are you asking for right now?
30 days, Your Honor.
Okay. We'll come back on June the 21st at 1:30.
Yes, Your Honor.
Your Honor, if I may.
Sure.
State would be in agreement to a $2,000 PR bond for Mr. Leo Alexander Rodriguez.
On each of those?
On the misdemeanors, Your Honor, possession of marijuana.
Okay.
Yes, sir.
And Your Honor, we are not opposed to a PR bond. My only concern, though, is that although at this point it may seem rather moot, the way credits work is the only way that Mr. Rodriguez is earning credits is if 1, he's detained and he's obviously satisfying that condition, and 2 is if there's a detainer. His family's still working on the felony bond. So if the court were to grant a personal bond now, he would only be earning credits on the felonies and not the misdemeanors. So we do have it in our back pocket and we would like to urge it, but we would humbly ask if we could urge it at a later time.
Okay, that's fine. I
Your
understand.
Honor, if I may.
Go ahead.
Right now, the felonies are set at $1,000 cash surety bond on each count. So by removing the possession of marijuana, he would have a $2,000 cash surety bond. Just for the court's information.
So Mr. Osuna, his family can't come up with $200?
It doesn't look like they've been able to post it, Your Honor. And my understanding actually was that it was, and I'd have to consult my records, but I had been in contact with Mr. Rodriguez's wife and she was trying to make something happen. I'll follow up again with her, but That's what we had been waiting on. And part of the
Okay, well,
hesitation might be,
what we can do, Mr. Osuna, is look, stay in contact with the family. If for some reason they can post the bond on the felony, then get them set up as soon as possible, or just submit it to me administratively for the reduction on, and to a PR bond on these two cases so that he can be released
certainly.
at
yes,
that time period. So either we can set him up or just do it administratively, and my staff will know that I'll approve it.
Yes, Your Honor, we'll do.
Okay? Because I don't want him there on these two cases. I don't want this to be the two cases that hold him in there.
Yes.
So if
And I
it's
think-
because they can't get the felony bond amount together, well, that's not on us, obviously.
Yeah, and I think the other reason, Your Honor, was that Mr. Rodriguez, because of his felony bond conditions, can no longer live at his own house. So I think that was also part of the delay that addresses it.
Okay,
Yes, Your Honor.
well, maybe he can find somebody else, somewhere else to live other than the county jail, probably,
Yes,
so. Okay, I'll go ahead and we'll stay with the setting of June 21st at 1:30.
June 21st. Yes, Your Honor.
Okay, Mr. Rodriguez, you are excused. Anything else?
Nothing further, Your Honor. Maybe excuse, please.
Yes,
Thank you.
thank you. Okay, Mr. Davila, what do you have, sir?
Yes, Your Honor. I have Jessica Marie Perez. That would be CR 22-03994-I.
Okay, is Miss Bettis still in custody or is she out?
I believe she's still in custody, Your Honor. This is me requesting a PR bond.
Okay, well, the female unit hasn't logged in yet, so as soon as they log in, I'll go ahead and recall your case.
Okay, Judge, I'll be here.
Okay, thank you. All right, Miss Arispe, what do you have?
Judge 6 and 7, she is bonded out, Judge. I don't see her on my screen, but I know she was logged in.
Okay, she's Spanish speaking?
No, ma'am, I believe she's English.
Okay, Jacqueline Duenes, are you present?
Yeah.
Okay, are you English speaking or Spanish speaking? Inglés o español?
Español.
Okay, please turn your camera on. Okay, por favor, quite el micrófono. Okay, she's here for an arraignment. Oh, no, she's not. We do, oh, yes, she is. On the possession of marijuana of less than 2 ounces, we had a waiver of arraignment pending. Well, and also the same on the failure to report. So I'm just going to go ahead and arraign her.
Yes, ma'am.
At this time, are you also asking for the NISI that was granted to be recalled?
Yes, ma'am. I believe there was one issued a while back.
Okay, that'll be granted. Ms. Castañeda, please have her raise her right hand.
Por favor, levante su mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
In CR 20-03560-I, CR 22-00480-I, State of Texas versus Jacqueline, Jacqueline Duenes, Duenes. Is that your true and correct name?
Okay. En el estado de Texas contra Jacqueline Duenes, ¿ese es su nombre correcto y verdadero?
Sí.
Yes.
Okay, ma'am, you're being charged with possession of marijuana of less than 2 ounces, a Class B misdemeanor, and a failure to report felony with SBI or death results, a Class A misdemeanor. A Class B misdemeanor carries a potential penalty of up to 6 months in Hidalgo County Jail and up to a $2,000 fine upon conviction. A Class A misdemeanor carries a potential penalty of up to 1 year in Hidalgo County Jail and up to a $4,000 fine upon conviction.
Okay. Está usted frente a la corte por una posesión de marihuana de menor de 2 onzas, que es una felonía menor clase B, y un delito de no informar los resultados de delitos graves o muerte, una ofensa menor clase A. Una ofensa menor clase B tiene una multa potencial de hasta 6 meses en la cárcel del condado de Hidalgo y una multa de hasta $2,000 por convicción. Una ofensa menor clase A tiene una multa potencial de hasta 1 año en la cárcel del condado de Hidalgo y una multa de hasta $4,000 por convicción.
Do you understand the range of punishment that you can receive for the offenses of which you are charged?
¿Entiende usted el rango de castigo que puede recibir por los delitos que está acusada?
Hold on, I think she got kicked out. She's coming back in.
Se me desconectó el teléfono.
I got disconnected.
Okay, did
Perdón,
she hear
perdón.
the range of punishment?
¿Escuchó usted el rango de castigo o quiere que se lo repita, ma'am?
Si me lo repite, por favor.
Una ofensa menor clase B tiene una multa potencial de hasta 6 meses en la cárcel del condado de Hidalgo y una multa de hasta $2,000 por convicción. Una ofensa menor clase A tiene una multa potencial de hasta 1 año en la cárcel del condado de Hidalgo y una multa de hasta $4,000 por convicción. ¿Entiende usted el rango de castigo que puede recibir por los delitos que está acusada?
Sí.
Yes.
Has any court ever declared you to be mentally incompetent, crazy, or insane?
¿Alguna corte la ha declarado mentalmente incompetente, loca o demente?
No.
No.
Counselor, in speaking with your client, do you find her to be mentally competent and able to assist you in her own defense?
She is mentally competent, Judge.
The court will make a finding that she is mentally competent and able to assist her attorney in her own defense, and also hereby enters a plea of not guilty on her behalf on each of the offenses of which she is charged. How much time are you requesting?
Judge, she does have a pending felony that just came in, Judge. I don't think it's yet in intake, but I was just recently appointed on the case on April 4th, I believe. So
Okay.
I think we're gonna need a little time for that one.
Okay, then we'll come back on August the 16th at 9:30, and that at this time will be via Zoom. Ms. Castañeda, please let her know August 16th at 9:30, and at this time it will be via Zoom.
Ms. Duenes, la próxima corte es el día 16 de agosto a las 9:30 y a este tiempo va a ser vía Zoom.
Ok. Corte el 16 de agosto a las 9:30, ¿verdad?
Correcto.
Ok.
Okay, and Ms. Arispe, if you can do me a favor and speak to her about courtroom etiquette and the dress, no sleeveless like that, and you know what I mean.
Yes, Judge, I will.
Okay, thank you.
Thank
All
you,
right, Ms.
Judge.
Castañeda, tell her that she is excused.
May be excused also, Judge.
Ms. Duenes, ya se puede retirar.
Ok, thank you.
Thank you.
Okay. Mr. Davila, we have the female unit on. Deputy, if you can please bring up Jessica Marie Bettis. Okay, is Ms. Bettis English speaking or Spanish speaking?
English.
Okay, that's on CR 22-03-994-I, State of Texas versus Jessica Marie Bettis. And Mr. Davila, your announcements?
Yes, Your Honor, I filed a motion to reduce bond. This is a possession of marijuana less than 2 ounces. And I am respectfully requesting a PR bond. She isn't able to make bond at this time.
Okay, and I believe she's also set for arraignment. Is that correct?
That is correct, Your Honor.
Okay, Mr. Lozano, your announcement?
Your Honor, she is PTD POM eligible. Paperwork was sent out on May 2nd, 2022. The state can agree to a $1,000 PR bond.
Okay, let me go ahead and arraign her first. Ms. Bettis, raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand. Is your true and correct name Jessica Marie Bettis?
Yes.
You're being charged with possession of marijuana of less than 2 ounces, a Class B misdemeanor. A Class B misdemeanor carries a potential penalty of up to 6 months in Hidalgo County Jail and up to a $2,000 fine upon conviction. Do you understand the range of punishment that you can receive, ma'am, for the offense of which you are charged?
Yes.
Ma'am, has any court ever declared you to be mentally incompetent, crazy, or insane?
No, ma'am.
And counselor, in speaking with your client, do you find her to be mentally competent and able to assist you in her own defense?
Yes, she is competent, Your Honor.
Okay. The court is going to find that Ms. Bettis is competent, able to assist her attorney in her own defense, and hereby enters a plea of not guilty on her behalf for the offense of which she is charged. The court is further granting the defense's request and is reducing the bond to $1,000 PR bond. Therefore, you will be released on your own recognizance, Ms. Bettis, okay? Further, Mr. Davila, so you, the PTD POM, do you think she plans on applying for that?
Yes, Your Honor, I do believe that that is going to be what we're going to be doing. I do intend to meet with Ms. Bettis when she gets out at my office so we can go over the paperwork and discuss that with her.
Okay, Ms. Bettis, as soon as you get out at the next business day, contact your attorney so that you can get started on that paperwork, okay? Ma'am, okay?
Yes, ma'am.
Okay. I'm going to give you a status date of August the 16th at 9:30, and that'll be via Zoom. Do you
Your Honor.
have Ms. Bettis's current contact information, Mr. Davila?
I am in contact with her family, Your Honor. Yes.
Okay. All right, Ms. Bettis, and I'll see you on August the 16th at 9:30. Get that paperwork in as soon as you can, ma'am.
Yes, ma'am.
Okay. Thank you. You have a good day.
Thank you, Your Honor. That's all I have. May I be excused?
You certainly may.
Thank you.
Deputy, I think that's all you have for the female unit, correct?
No, Your Honor, I have one more female. Her name is Jimenez Yvette.
Oh, okay. Mr. Morales, I believe that's a plea. Is that correct?
Yes, Your Honor, that's a plea.
Okay, give me one moment. Deputies in the male unit, the attorneys for those haven't logged in yet,
Okay, that's fine.
just to let you know. All right, so Ms. Jimenez, she's pleading to the theft and dismissing on the failure to identify?
That's correct, Your Honor.
Okay, is that dismissal as part of the plea or is it separate? Did something else happen?
It was part of the plea bargain on the felony case, Your Honor.
Okay, Mr. Lozano, were you going to add something?
No, Your Honor, that's correct.
Okay. So then the dismissal on the CR 21-11436-I is already taken care of in the felony paperwork, correct?
That's correct, Your Honor.
Okay. Okay, Ms. Jimenez, is she English speaking or Spanish?
English.
Okay, Ms. Jimenez, can I please have you raise your right hand? Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may lower your hand. In CR 20-00891-I, State of Texas versus Yvette Perales Jimenez, is that your true and correct name?
Yes, Your Honor.
And you're being charged with theft of property of greater or equal to $750 and less than $2,500. And that is a Class A misdemeanor. A Class A misdemeanor carries a potential penalty of up to 6 months in Hidalgo County Jail. I'm sorry. A Class A carries up to 1 year in Hidalgo County Jail and up to a $1,000 fine upon conviction. Sorry, I'm trying to do two things at once because my mouse already disconnected on me several times. Hold on. Now, ma'am, let me repeat that because I even confused myself. So a Class A misdemeanor carries a potential penalty of up to 1 year in Hidalgo County Jail and up to a $4,000 fine upon conviction. Do you understand that range of punishment, ma'am?
Yes, Your Honor.
Okay. You have a right to an attorney and you have a right to a trial by jury. You can waive one or both of those rights by signing a written document with this court. Did you have an opportunity to review that document before signing it, ma'am?
Yes, Your Honor.
Okay. And did you understand that when you signed that document that you were waiving your right to a trial by jury?
Yes.
Then the court will accept your waiver of trial by jury. Has any court ever declared you to be mentally incompetent, crazy, or insane?
No, Your Honor.
Then, counselor, in speaking with your client, do you find her to be mentally competent and able to assist you in her own defense?
I do, Your Honor.
The court is making a finding that she is competent and able to assist her attorney in her own defense. Do you also understand, ma'am, that if the punishment I assess does not exceed what's recommended by the state, you will need to file, you will need this court's permission if you decide to file an appeal?
Yes.
And do you further understand that the court doesn't have to accept the state's recommendation?
Yes, Your Honor.
Ma'am, are you a US citizen?
Yes, ma'am.
In CR 200891-I, State of Texas versus Yvette Perales Jimenez, to the offense of theft of property of greater or equal to $750 but less than $2,500, a Class A misdemeanor. How do you plead? Guilty or not guilty?
Guilty.
And are you doing so freely and voluntarily?
Yes, Your Honor.
Then the court will make a finding that you have entered your plea of guilty freely and voluntarily. I will call for state's evidence at this time.
Your Honor, state offers plea documents and offense reports as State's Exhibit 1, notification and certification of defendant's right of appeal as State's Exhibit 2, waiver of Article 3914 disclosures as State's Exhibit 3, waiver of risks and needs assessment as State's Exhibit 4. State would also request defense counsel stipulate to the venue and jurisdiction of this honorable court and stipulate that the evidence has been e-filed is sufficient to corroborate a plea of guilty.
Having reviewed all exhibits with my client, I have no objection and so agree and stipulate.
All right, there being no objection from defense counsel as to the exhibits are hereby admitted and approved. In CR 200891-I, State of Texas versus Yvette Perales Jimenez, it is a judgment of the court, ma'am, that you are guilty as charged. And what is the state's recommendation?
Your Honor, the state recommends a $100 fine, court costs, 229 days Hidalgo County Jail, credit for 229, and a due and owing of $600 to Easy Pawn.
Counselor, any questions or requests on behalf of your client?
Your Honor, since my client is going up to TDC for a 5-year sentence on her felony cases, would Your Honor consider waiving the, I think it was the fine or the fee? And court
Yes.
costs?
In light of that, the court is waiving the fine and the court costs. The rest of the recommendation I will follow.
Thank you, Judge.
Okay, Ms. Jimenez, best of luck to you, ma'am. If nothing further, you and your attorney are excused.
Thank you, Your Honor.
Have a good
Thank
day.
you. You too.
Your Honor, that's all we have for the female section. May we be excused?
Yes, ma'am, and thank you for your service.
Thank you.
Okay, Mr. Contreras?
Your Honor,
Yeah.
good afternoon, Your Honor. I do have Hector Castro on your number 2, 3, and 4 on your docket, Your Honor. 2, 3, and 4.
And 5.
And 5, yeah.
Your Honor,
Okay, go ahead.
Your Honor, if I may, that defendant Hector Castro was taken back to his section. He was being very disruptive and very uncooperative in the courtroom. So we had him removed.
Okay, I'll go ahead and take the announcements from the attorney, CR 19-16048-I, CR 21-08084-I, and CR 22-00832-I. All right, let the record reflect that Mr. Castro was taken back to his cell due to being disruptive. So go ahead, Mr. Contreras.
For the record, Jesse Contreras for Mr. Castro. Your Honor, on the cases that are before this court, Your Honor, number 2, number 3, and number 4 have been dismissed as part of the plea bargain out of the 398th District Court. The gentleman got 2 years TDC, Your Honor. The only thing that was left remaining, number 5, which is the assault. And that one, I would ask the state they can forward time served or whatever documentation, because he's been there for more than 6-7 months, Your Honor. So we left it. Mr. Esquivel, OJ Esquivel, agreed that one's going to remain open until we plea him out in your court, Your Honor. So I would ask the state again, they can send me the plea documents, Your Honor.
Mr. Lozano, go ahead.
Your Honor, the documents were sent out yesterday and they were sent out previously on May 6th on the assault. The state will be submitting a dismissal on CR 21-08084-I as part of the felony plea agreement. CR 21-09299-I has already been dismissed. I'm still verifying on CR 19-16048-I, which is the evading arrest.
No objections, Your Honor, on the dismissals on number 2, 3, and 4 of your docket, Your Honor?
Okay, well, he's only stating at this time 3 and 4 and that he's verifying a dismissal on 2.
No problem. You can look at the judgment, Your Honor.
Okay.
The 398th judgment, and it reflects number 2, number 3, number 4 being dismissed, except again, the assault pending.
Okay, so the paperwork on the time served was emailed to you on May the 6th, so you should have that.
Judge, and for the record, he's been set up for a plea sign up already for Friday, Your Honor. So I would ask a plea maybe Tuesday, Wednesday of next week, if possible, so we can clean them up.
Okay, that's fine. It can be on the 17th, May
Yes, Your Honor.
17th at 1:30.
He is incarcerated. You're gonna have the prisoner taken upstairs, Your Honor?
No, it'll be via Zoom.
Okay, perfect. Thank you, Judge. That's all I have regarding Mr. Castro. I don't have any other cases, Your Honor. May I be excused?
Yes,
Thank you so much.
thank you.
Okay.
Okay, Mr. Rodriguez?
Yes, Your Honor.
Okay, it's Francisco Perez, correct?
Correct, Judge.
He's coming, Your Honor. He's a Spanish speaker.
Okay. Okay, this is on F 35304-19-9 and announcements.
Judge, we're here. My client is here, Maria Delgado. We initially were the respondent, and we filed a counter petition for this divorce case. And the whole time that we've been involved in this case since 2019, Judge, the petitioner, who has had two different lawyers, Your Honor, is now pro se again, and he's been incarcerated ever since. And as of yesterday, Your Honor, if you look on Odyssey, he has still got criminal charges, and it does not look like he's going to get out of jail anytime soon.
Okay, Ms. Castañeda, please ask Mr. Perez if he'll be representing himself in this divorce today.
Señor Pérez, ¿se va usted a representar solo en este divorcio?
No, yo tengo que tener mi abogado.
No, I have to have my attorney.
And who's his attorney? Because there's no one showing that it's his attorney. Who does he think?
¿Y quién es su abogado? Porque no nos entendemos. ¿Tiene abogado?
Juan Álvarez.
Juan Álvarez.
Your Honor, Mr. Juan Alvarez was allowed to withdraw, and he has withdrawn.
Yes, please let him know that Mr. Alvarez is not his attorney. He has already been allowed to withdraw from the case.
El señor Álvarez no es su abogado. Él ya se retiró del caso.
Bueno, yo le mandé una carta. Le mandé una carta para que me den otra restricción para agarrar otro abogado.
I sent a letter to get an extension so I can get another attorney.
Mr. Rodriguez, what are the issues?
Judge, there are 3 children, and there's 1 house and 1 truck. That is the entire amount of the issues. The parties were married in 2018. They only lived together as husband and wife during the marriage of 6 months, even though they had 3 children together. And he was arrested in 2019. And since then, there's been absolutely no support. She's a single parent raising 3 children, living in the only house. Both of them are illegally here in the United States. So if he does even get out of jail, Your Honor, he's going to be deported.
Okay. So the children that are in question in the felonies that are against him, are they the children of this marriage?
Correct, Judge. That's correct.
Ms. Castaneda, ask him what it is that he's fighting for in this marriage.
Señor Pérez, ¿qué es lo que está usted peleando en este matrimonio?
En este matrimonio que yo hice en mi casa, propio yo mismo la hice y yo pagué el solar con mi dinero.
That I made the house and I paid for the
Y yo quiero que me den más tiempo para agarrar un abogado.
I want to give me more time to get an attorney.
Okay, so Mr. Rodriguez, just so you know, Mr. Perez was not given notice that Mr. Alvarez had withdrawn. It says that the notice was returned unserved because they sent it to his home instead of to the jail. But on this home, the property that it's on and the home, okay, tell me about the homestead.
The homestead.
Like the property, okay, give me again, what dates were they married?
They were married in, I have marriage a date of June of 2018. They were separated December 2nd of 2018, that same year.
Okay, so the home was built on a lot that was the home built during the marriage? Or what year was the home built?
The home, Your Honor, was built in 2007.
Okay.
And both parties, yes, both parties are listed on the original note that was used to purchase the land and build the house.
Okay. So I can't deny him to hire new counsel when he's asking to hire new counsel. However, what I'm gonna do is I need to have you all in person, because if he doesn't get counsel by the time we do this in person, we're moving forward because he had an opportunity to do it. You know what I mean?
Right.
And so in order to do that, of course, I'm going to have to question both of them because he'll be transported down there. And then I also need to see, because if they built the home in 2007 and they were both listed on there, then obviously, even if they weren't married, they were tenants in common.
Correct.
Okay. So I'm not saying he's entitled to half of the equity, because I don't even know if there's any equity in there yet. Okay. And I don't know if you are making any civil claims on your petition in light of what he has done. I mean, he's being accused of doing that. Let me rephrase that he's being accused of doing. So I do not know if you have anything in your counter petition for a disproportionate share that she would be entitled to in light of the situation. I don't know if you have that on there. And if you don't, I'm not sure because if you're looking for me to make a ruling, let's just say that it's agreed to that they do own this property together. And if you're looking for me to make a ruling down the road for a disproportionate share to her or all to her, whatever it is, it would need to be in the pleadings for at least 30 days before the hearing, the next final hearing. So I don't know if it's in your counter petition. Do you know?
It's been a while. I'd have to check and see, Judge. Off the top of my head, Judge, I don't know.
I don't even know where the counter petition is, because this is it's been a long time.
Judge, if I may, it was filed on 10/28/2019.
Okay, it's not pled, Mr. Rodriguez?
Yeah, it's not pled, Judge. The only thing at that time that I did the counter petition, we just were pleading on behalf of the children.
I understand.
Yeah.
So, but now these issues have arisen. So, I mean, I'm not going to tell you what to do, but if you're wanting an opportunity to amend your counter petition to include that relief so that we take it up all at once, that's up to you.
Okay.
Because if that's the case, then we would have to reset this for about 45 days out, because it does need to be on file for 30 days prior to. Well, actually, you have to give them 30 days notice.
Notice, yes. So I would need additional time to get it to him. And with the understanding, Judge, that this, if he decides to retain counsel now again, that'll be the third time, I need to make sure that he knows that we've had DCC orders in place and never once has he complied with anything having to do with a DCC order. He has not complied with going to mediation. He hasn't complied with answering discovery. And this why this case is dragged on behalf of my client.
So Ms. Castaneda, let him know that there was a DCO in place and they didn't comply with the deadlines.
Señor Pérez, hubo un DCO que estaba en línea y no siguieron las órdenes de la corte.
No, estábamos en línea cuando el abogado vino que dijo que iba a venir conmigo. La corte, que la primera corte que me hicieron, yo le dije que yo no había corrido a mi abogado. Y el abogado ayer, yo le hablé y le habló a mi hermano. Y mi hermano fue con el papel que me mandó usted. Me mandaron la palabra Hinojosa, me mandó el papel. Y yo mandé a mi hermano con el papel para allá para ver qué, porque el abogado ya no quería ayudarme. ¿Qué es lo que yo podía hacer? Porque yo necesito otro abogado como quiera.
Okay, just let him know. I mean, if you want to translate that, you can.
As best as I can, ma'am.
Sure.
They sent me a notice and I sent my brother with that notice to the attorney's office because regardless, I need an attorney.
Okay. So Mr. Rodriguez would actually, since they have any amendments have to be on file at least 30 days before the final setting, which means that it's actually, you know how everything has to stop 30 days before the final hearing date. So it's actually 60 days before. So I'm going to have him have y'all come in person on August the 18th at 1:30. So your amended counter petition would need to be on file by 30 days before that date. And then he would need his notice in order to be able to amend it. That's why I did it 60 days out. So it's August the 18th at 1:30, and that'll be in person. Ms. Castaneda, let him know that it'll be August 18th at 1:30, and he needs to hire that attorney as soon as possible.
Ok, señor Pérez, la próxima corte va a ser el día 18 de agosto a la 1:30 de la tarde y va a ser en persona. So necesita usted contratar su abogado lo más pronto posible.
Y no me puede dar una extensión más larga para yo poder, porque yo también aquí estoy encerrado, yo también tengo que buscar allá hablar con mi familia.
Okay, and you can give me an extension longer because I'm here and incarcerated and I need to talk to my family.
No, because this will be his third attorney and we cannot force this lady to continue to stay married to him.
Okay, no, porque este va a ser su tercer abogado y no podemos obligar a la señora a que esté casado con usted.
Este es el segundo abogado.
This is my second attorney.
Okay, August 18th at 1:30.
Agosto 18 a la 1:30, sir.
Okay.
Okay, thank you, Deputy. Do you have anybody else?
No, ma'am, that's it.
Okay, thank you. You have a good day.
You too, ma'am.
Thank
Thank
you
you.
for your service.
Yes, ma'am.
Okay, Mr. Rodriguez, August the 18th at 1:30 in person. And then hopefully we can finish it on that date.
Okay, I will tell my client, Judge, and that's it. Nothing further. May I be excused, Your Honor?
Yes, make sure that for that setting on August 18th at 1:30, you have anything you need for me to look at to make a determination with respect to the character of the property, and also such as who paid it or whatever it is. I don't know if they're claiming a common law marriage up to that point or what, or if not, it would be tenants in common if they were both on that deed. So anything you need for me to look at to make any kind of determination as to the character of the property, make sure that you have it for that date.
Okay.
Okay.
All right. And Judge, do you know what courtroom that'll be in yet, or do we
As
wait?
of right now, it'll be court 4
Okay,
as of right now, but check with us as it gets closer.
okay,
Because I don't know, supposedly we might be in the new courthouse, but I don't know.
okay. All right. Thank you, Judge.
Okay, thank you.
Thank you, Judge.
Okay, that concludes this afternoon.